Hmm. Hey, and welcome to this week's edition of the Life and Legacy Show, sponsored by the Sechler Law Firm, where great families make great estate plans. My name is Tim Sechler. I'm a certified elder law attorney, and I am your host of this show each and every week, where we talk about all things estate planning, elder law, how to protect yourself, your family, and your money from the government's crazy rule book. And at the end of the day, that's what we're really talking about. So today's episode, I should say this before we get into the content, because I'm a lawyer and I've got my own lawyers, and they say that I need to tell you I am not your lawyer. If you need legal representation, we're available anytime. Phone number 724-841-1393, or you can go to seclerlawfirm.com, Secler lawfirm.com, and learn more about how we do things and how we can help you. And so this show is for your information and education. It's not legal advice. Don't make any decisions based on what you hear today. Okay, with all that out of the way, we're going to talk about some of the most common questions that I get in the firm and at our estate planning workshop. So if you're not familiar with who we are and what we do, we have a bunch of education events all over town, teaching people the things that you need to know in order to make a great plan for your family. So one of our core concepts around here is that educated decisions tend to be better decisions, more confident decisions, just better decisions, but you can make them more confidently, better informed if you do some education first. And so with us, we try to do the education for free, which is why we run estate planning classes in both North and South Pittsburgh, teaching you the things you need to know to protect your family. Now, here's the thing about estate planning. One of the questions that we get all the time, which is where I really want to focus our conversation for today's episode, is people ask us all the time, which is better, a will or a trust? Now, if you ask 12 attorneys which is better, a will or a trust, you are highly likely to get 12 different answers. And so we all have our different philosophies, right? Just like in cars, you got Chevy guys and Ford guys and foreign guys. Uh, in the estate planning world, we have different tools that we like to use. And my goal is to make sure you understand the tools that you're choosing. Not to say that one is better than the other. A trust is not better than a will. A will is not better than a trust. They do different things. And so your job in trying to protect your family is to understand how these tools are used, why the tools are used, what problems are they trying to solve, and then you can decide on the tools that you like to use. And so we're going to do a little bit of that today. And then I want to just sort of explain the way that we do things. And so we're going to talk all about these tools, right? We're going to spend a half an hour dissecting the most popular estate planning tools. But I want to start with this, and then at the end of the episode, we're going to close it up by saying it is almost impossible, if not impossible, to write the perfect estate plan. Like if you were to ask me, what is the perfect estate plan? Well, I could do that for you. Here's what I would need to know. I would need to know, what day are you going to pass away? How old will you be? How much money will you have? Is your spouse still alive? Are your kids alive? Are your kids in healthy marriages? Do you have any underage grandchildren? Has anybody in your family been sued? Are there any disabilities? Do we have any divorce problems? Do we have any addiction problems? Do we have any lawsuit problems? Do you live in Pennsylvania and do we have to worry about the inheritance tax? Like if you had all these variables for me and you were able to tell me all those things and probably half a dozen other ones, I could probably write you the perfect estate plan, because at that point in time, we know exactly what the problems are that you're going to face. We can solve them. Um, if you can't tell me that, then it is impossible for me to write you the perfect estate. And so then what I want to teach is how we can do next best, right? So what's the next best option? If we can't do perfect because we can't choose exactly the right tool because we don't know what is going to break, what's the next option? And so let's talk about some of these tools. So one of the most common tools that should be involved in every estate plan, and think about an estate plan, like one way to think about your estate plan is your estate plan is just your rule book. Okay. So the state of Pennsylvania has a rule book for all of this stuff. They have a rule book for what happens with your stuff when you pass away. If you don't do anything else, they've got a rule book for you. But the number one rule in the state's rule book is you get to make your own rules. You can write your own rules about how you want your life to go and about how you want things to be divvied up when you pass away and who's in control and all those things. You can do it yourself. if you take the time to do your own rule book. If you don't take the time to do your own rule book, you're stuck with the state's rule book. And the state's rule book says courthouses, and it says legal, excuse me, legal fees, and it says the nursing home going broke if you end up in the nursing home if you don't plan for that. Government's rule book is not a friendly place when it comes to long-term care. And so if you want to leave your family and your money, your life savings subject to whatever the powers that be in Harrisburg decide, then you shouldn't do an estate plan. If you want to know how things are going to go for your family once something happens, whether it be a disability, an illness, or when you pass away, if you want to know how we can protect your family and your money from some of those issues, well, then you better saddle up and get this thing off of the back burner and do an estate plan because we don't know when that's going to happen. Quit pretending like it's going to be in 50 years. It may not be. And so we've got to plan for this stuff. You know, one of the things that I tell young families when I'm working with them, young parents, little kids, et cetera, is look, you got to plan for your own absence. It's not an option, right? It's too important. Your kids are too important. Your money is too important to not plan for this. So you need to get it off the back burner, get it to the forefront, talk about it, learn your options, make a decision. Um, and so, but let's talk about some of these tools you'll be thinking about and talking about. First is the power of attorney. Any estate plan should have a power of attorney document. Now, the way the power of attorney documents work, there's really two broad types of power of attorney documents. There's a durable power of attorney, and then there is a springing power of attorney. Now, a springing power of attorney springs into effect when you later lose capacity. You could sign it today. It's not effective today. It's effective when you later lose capacity. A durable power of attorney is a document that you sign it today. It's effective today. It remains in effect when you later lose capacity. Um, we lawyers tend to use durable powers of attorney way more than we do springing powers of attorney. And the reason for that is because the springing power of attorney requires there to be a determination that somebody's incapacitated or at least can't make decisions on their own best in their own best interest. And that's a problem because nobody ever wants to admit when they need help. I'm not going to go see your doctor, Sonny boy. You're just trying to take my car keys. I see what you're doing. I'm not going to go see your doctor. Therefore, you're not gonna get any authority under the power of attorney. And now we got a family who's lost control, right? Dad has capacity. We don't have the ability to do anything now because dad won't go see the doctor. We end right back up in the courthouse, which is one of the reasons that we decided to do a power of attorney in the first place was to not lose control in the situation and to avoid the courthouse. And so we use durable power of attorney documents. Now, the durable power of attorney document is a document that you sign today and it is effective today and it remains in effect later when you lose capacity. Okay. So it works today, it works tomorrow. Um, these are way more favorable because if you think about it, people with dementia, for example, capacity slides over time. Kids are picking up the slack over time. There need not be a determination that mom does or does not have capacity. We just know mom needs some help and the kids can help. All right. So, from a practical standpoint, we want to use durable power of attorney documents. Now, if you have a power of attorney, I would suggest that you get it out and read it. All right. If you listen to one thing I'm going to say in today's episode, read your power of attorney document. One of the things I want you to look for is the word gifting. Does your agent, does your power of attorney have the ability to give your stuff away? Now, where does this come in? Well, it's incredibly important when someone um, loses capacity, someone's in a nursing home, and it's usually the healthy spouse or the adult children who are in our office wanting to know, is there anything we can do to protect the house? Mom's going through all of her money and I'm the power of attorney, but we don't want to continue to lose $14,000 a month to Alzheimer's disease. What can we do now? And we call these types of cases Medicaid crisis cases. We help a handful of families every single month with this issue. But we almost always have to be able to gift the money away. And so when it comes to the provisions that need to be in a power of attorney document, my opinion is we need to have unlimited gifting language in these documents. Now, of course, you need to consider your own situation. You can chat about this with us or with another lawyer about what's right for your situation. But I think it's important to at least consider power of attorney with unlimited gifting language because when somebody ends up in a nursing home, it's the gifting language that helps us protect assets, which seems to be pretty important at that point in time. So I would encourage you to read the power of attorney document. And if you don't see unlimited gifting authority, if you just see some vague gift reference to gifting or reference to a tax code, that might be a document you consider getting updated. So that's how we shift control in the event of incapacity. Now, another tool you need to know about, and most people know most about, is the will. So if I had to ask any collection of a random group of 10 people, what's the first document you think of when you hear the words estate planning? For most people, the answer is they're going to think about the will first. But here's the question about the will. What's the primary purpose of a will? The primary purpose of a will is to get this stuff to the kids when you pass away. Okay, well, that's an important question to answer. Who gets it? That's an important question to answer, but it's not the only important question to answer. What about what happens if that person dies before me? What happens if it's going to young people? What happens if it's going to underage people? What happens if my daughter's in the middle of a divorce? What happens if I leave everything to my spouse? And when I die, I'm my wife's primary caretaker. When I pass away, she's going to end up in a nursing home. If I leave everything to her, now who gets the money? Right. And so there's some other questions we probably want to think about other than just who gets it, because who gets it is overly simplistic. It pretends we're all going to live in a world where, we live to 97 years old, die in our sleep one night after playing, pickleball all afternoon, and doing Sudoku. But that's not real, right? I mean, that's not how it goes for everyone. Um, and so we need to plan for some other things. And so now, one of the other challenges with a will, and this is a point that we talk about an awful lot in our Three Secrets workshop, our estate planning workshop, Three Secrets to Protect Your Legacy, which you can register for on our website, sechlerlawfirm.com, Secler lawfirm.com, and come learn about these things. We'll teach you some of these things. But one of the things we talk about in the workshop is that wills have to go through probate. Now, probate, people will talk to you about avoiding probate. Lawyers will talk to you about avoiding probate. Your friends probably talk to you about avoiding probate. Um, Financial advisors will talk to you about avoiding probate. So, should you avoid probate? Well, maybe. I think in a lot of cases, yeah, the answer is yeah. If I can avoid the courthouse, I've been trying to avoid the courthouse my entire life. Why do I want my kids to have to go through this process when I pass away? And if I pass away with three kids, why do I need a judge's help to divide my estate by three to give it to my kids? Why is that a legal matter? And so a lot of people want to keep this more of a private thing, and we end up using trust to avoid probate. Now, here's a couple other reasons why I think you might want to consider avoiding probate. One is the expense of it. Legal fees in a probate matter can be pretty expensive. It's very common for lawyers in Pennsylvania to charge on a percentage of your net worth to help get the kids to the stuff. So one, it can be to help the stuff get to the kids. It can be pretty expensive. Another is this: if you do end up in a nursing, okay, so if you listen to the Alzheimer's Association, 1 in 3 of us are going to have dementia. 2 out of 3 of us are going to need some form of long-term care. That's according to longtermcare.gov. And north of 20% of us are going to need more than 5 years of care. All right. Nursing homes are $150,000 a year today's dollars. What are they going to be in 10 years? 200 grand a year. And families are going through this. And so I think we need to be thinking about asset protection. Now, here's the interesting thing. People that do go through all their money, one of the things that you're allowed to continue to own, and then the state will pay for your nursing home once you go broke. But one of the things you are allowed to continue to own is a primary residence. You're allowed to still own a house, be in a nursing home, state's paying for the nursing home. Here's the problem. When you pass away, the executor of your will, where your house is going to go through your will at that point in time, the executor of your will is going to have to sell the house to pay back the state of Pennsylvania for every penny they spent on your nursing home. So if you end up owning a house and end up going through the nursing home issue, you don't necessarily get to keep the house. I mean, they don't count it from an eligibility standpoint, but don't draw the second conclusion that means the family's going to get to keep the house or the value of the house, because there's a significant chance state's going to come seeking those monies out of the estate recovery claim. Now, here's the interesting thing. The estate recovery claim in Pennsylvania is limited to your probate estate. It's limited to the probate estate, the assets that go through the will, which of course is where the house is going to go if you use a will-based estate plan. And so it's as simple to avoid the estate recovery claim and have the house in a trust that avoids probate, and you avoid the estate recovery claim. Now, there's different types of trusts that we want to use, but let's just make a point on this. There's 100,000 lawyers out here in the world that's telling their clients that, look, you're not rich, you don't have some major tax concern. And because you're not rich, all you need is a simple will. You don't need to do any of that trust stuff because you're not wealthy, and it's going to be simple. Unless, of course, you're one of the 20% of people that end up in nursing homes for more than 5 years or long-term care for more than 5 years, because then we're probably going to lose your house. And like, for the life of me, I don't understand why more lawyers aren't talking about this. Why aren't we talking more about putting houses in trust if that's what it takes to protect it from Alzheimer's disease, which 1 in 3 of us are going to have if we reach age 85? And so we like to put houses in trust. Now, we like to put other assets in trust too. So one of the key things that I like to educate people on is this tool called a trust. Now, we like to use a little red wagon to describe the concept of a trust. Imagine a little radio flyer wagon. To my radio listeners, you got this little radio flyer wagon. There's 3 people involved. The person who creates the trust signs the legal document. Well, that would be you. You're what's called the grantor. You created the trust, and you're going to grant ownership of some stuff into the trust. You put house in the trust, retitle the house for some money, some financial accounts into the trust. Now, the trust, you could think of it like the trust now owns the stuff. The person in control of the trust has the handle to our little red wagon. That person is called the trustee. So that's the person making the decisions. That's the person in control. The people who are allowed to use the stuff that is now in the wagon, those people are called beneficiaries. So 3 people. Grantor creates it. Trustee is in control. Beneficiaries have access. Now, in some trusts, I want to be all 3 people. I want to create my trust. I want to put my stuff in the trust. I'm going to be my own trustee, my own beneficiary. I'm going to use this money however the heck I want for the rest of my life. If I'm all 3 people, we're talking about a thing called a revocable trust. A revocable trust. I put the stuff in there, and then next week life is back to normal. Using the money however I want, spending the money, saving the money, living in the house, selling the house, doing whatever the heck I want the same way I could last week, I can do next week. But the difference is, when I pass away, I don't technically own the stuff anymore. The stuff is being held in trust for the benefit of my kids at that point in time. And if we have stuff in trust, they end up avoiding the probate court. So revocable living trusts are largely used to avoid probate. Okay, that's a good problem to solve. It's good to understand that that's what occurs. But it's not the only problem we got to solve. I want to suggest to you should consider another tool called an irrevocable asset protection trust. Now, when I use the word irrevocable, I know that, like, somebody's driving down the highway listening to this show right now, and I just recommended the idea of considering an irrevocable trust. And someone darn near drove off the interstate, right? There's no way I would do irrevocable. That's so permanent. That's so set in stone. I give up control. La da 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 da. That's not necessarily true, right? You can use these trusts and maintain different types of control. But what you do is you give up access. You can't have it back. If you want to get it back, you got to involve family members, right? You got to, the trust has beneficiaries. The beneficiaries typically be your kids. There's nothing to prevent you from writing your kids a check. And in most families, kids still love the parents and could give the money back. So, for a lot of families, using an irrevocable asset protection trust could be a pretty good idea, because after we have our stuff in the trust for 5 years, now we have protected this stuff from the nursing home, which seems to me to be a pretty big idea, right? We want to protect some stuff. I mean, if you're a retiree or soon to be retiree, let's be honest, your biggest financial threat is the nursing home. And I hope you never go to the nursing home. Plan A is never go to a nursing home. Plan B is, if you're going to go to a nursing home, let's make it 5 years after we've done some asset protection planning. Let's create your own rule book. Going back to the top of the show, let's create your own rule book on how it's going to go, right? I want a rule book that understands and contemplates how I could protect some money and protect the house for my wife if I have dementia. That's going to be part of my rule book, right? But if I don't take the time to write the estate plan, like, there's somebody listening to this show right now, I can promise you, that knows that they need to do an estate plan. You probably know you need to do an estate plan. You've never done it, or it's been a long time and it needs to be updated. Maybe you got that will from when the kids were little. You need to do an estate plan. That estate plan is going to have certain tools in it. One of the tools you should consider, like, think of an estate plan just as a toolbox, like a physical toolbox, rather than wrenches and screwdrivers and hammers. It's got powers of attorney and wills and trusts in it, but it's your own toolbox for fixing things that could go wrong. when I get sick, when I pass away, if someone's disabled, we got the right tool for the job. Now, I was at the top of the show. One of the things, like if you come to one of our three secrets to protect your legacy workshops, which I encourage you to look, we get great marks, we get great reviews on our workshops. You should come. We're going to teach you a bunch of great and interesting information. No obligation. Leave your checkbook at home. You can hire us at the workshop. And we're just providing some education. Now, hopefully, yeah, we're looking to earn your business, but not that night. This is an educational topic. So come in and learn about these tools. What's the difference between a revocable trust and an irrevocable trust? Why would we recommend one or the over the other? But I want to point out a thing that I think is wrong in the estate planning industry. The estate planning industry has evolved, right? Over time, it's changed, it's fluctuated. And one of the things that has changed and fluctuated is we've got different tech. We've got software to draft documents. We're not like handwriting these things anymore. And one of the things that I think is a problem is lawyers make their clients choose a tool, right? So, and I did this. Look, I did this for 10 years this way. This is the way I was trained. It's the way I thought it was supposed to be done. I would do initial consultation with lawyers, with potential clients. We'd meet all day for an hour and a half, 2 hour meeting. And then at the end, I would say, okay, now that you understand the difference between a will and a revocable trust and an irrevocable trust, which one do you want? And then they would make a decision. Now, there's a price tag associated with that decision. Trust can get pretty expensive. Here's the problem. Which one do they want? Which one do they need? Which one do they need? I don't know. I don't know what day they're going to pass away. I don't know what the tax code is going to be that day. I don't know how much money they have left. I don't know if the kids are in a good marriage. I don't know if they've needed a nursing home. I don't know any of that stuff. And so if I can't know that stuff, I cannot write them the perfect estate plan. It's impossible. How could I design a tool for a problem we don't yet understand? Um, and so one of the problem in the estate planning industry, the way that we see it at our law firm, is you're making people guess. And if they guess wrong, boy, there's some good, big financial ramifications for this. And here's the thing that breaks is typically the person's mental capacity to where they can't sign future documents in the future, right? You got to get it right the first time. And if you got to get it right the first time, but it can't be perfect because we don't know what's going to break next. The philosophy that I have, the philosophy that we share at the Sechler Law Firm, it's really a simple concept, but it's a shakeup in the legal industry. There's nobody else in Pittsburgh that's about to say what I'm about to say. Is if you want to work with my law firm, I'm not going to make you decide between tools, right? Any of the tools we just mentioned, wills, powers of attorney, revocable trust, asset protection trust, it's like a good, better, best model. Like a will is good. This trust is a little better. That trust is best. Which one do you want for your family? Why would anyone come to my law firm that didn't want to do the best thing for their family? Like raise your hand. Well, I can't do this because we're not in person. Do you want to just do a good plan for your family, or do you want to do the best plan for your family? And most people that are serious about taking care of their loved ones want to do the best for their family. So what does that mean? Well, we can't do a perfect estate plan because we don't know what's going to break and when you're going to pass away. Seems to me, let's just load up that toolbox with everything you could need. And so when we work with families, in particular, this is in the retiree space, soon to be retired space, we typically just do all the documents. I would rather have you have tools in your toolbox that maybe we never use than to have a thing break and not have the tool. And with the software we have and all the rest, if we're smart about it, which I think we are at our law firm, we can get pretty efficient about producing these tools. It doesn't have to cost $15,000 to do it the right way. Doesn't have to cost half of $15,000 to do it the right way. We can do this pretty effectively, but don't guess. It's too important. Why would we leave our clients exposed to the risk of having made the wrong decision, what to save a couple $1,000 when we could have all the tools the family could possibly need and then form a relationship with the client on when to pull out the right tool out of the toolbox rather than treat our clients as a transaction. So at the Sechler Law Firm, what do we do? Our process is we ask you to come through a series of classes where we teach you the tools, you make some decisions on what your documents need to say. We just load up that toolbox with everything you could need. And then we have an ongoing program called the Red Wagon Club to make sure that the estate plan shifts over time, because what our clients tell us they hire us for is for peace of mind. I don't think peace of mind is a thing you want for a day. I think it's a thing you want probably for the rest of your retirement. And so this is the best way to do it. So we've sort of cracked the code, I think, on this stuff. It's been extremely popular. You can find out all about it by going to sechlerlawfirm.com, Sechler lawfirm.com. If you know you need to do an estate plan, if this has been on the back burner for you for a long time, this is the best way to get it done. Come to one of our free education sessions, learn all about it. Let's make some great decisions for your family. I hope you found this episode informational. I hope you found it educational, but remember, it's not legal advice. Don't make any decisions without the advice of a lawyer. We're here anytime at 724-841-1393 or sechlerlawfirm.com. Thanks for listening. We'll see you here next week.